In February 2026, the constitutional boundary between executive trade power and judicial oversight reached a breaking point. The Supreme Court issued a landmark ruling that invalidated a massive architecture of tariffs imposed under the International Emergency Economic Powers Act. For years, the White House used this act to shape global trade strategy. But the court has now declared the statute does not authorize the president to levy such duties. This isn't just a legal technicality, it is a shockwave hitting the American economy, immediately dropping effective tariff rates for certain sectors from 15.3% down to 8.3% and leaving billions of dollars in paid duties in a legal limbo. As businesses scramble to recalculate costs for the upcoming season, the ruling forces a fundamental reevaluation of how the United States engages with the global market. Conflict over who controls the power of the purse regarding trade dates back to Article 1 of the Constitution, which grants Congress the sole power to lay and collect duties. However, throughout the 20th century, the legislative branch began delegating this authority to the president to allow for faster responses to international crises. This shift accelerated with the Trade Act of 1974 and the 1977 passage of the International Emergency Economic Powers Act. Historically, these tools were designed for targeted sanctions against hostile actors, or specific economic emergencies. Over the last decade, however, that narrow scope expanded into a broad-based tool for general economic leverage. By the time we reached 2025, the act had become the primary engine for reciprocal trade wars, a far cry from its original intent as a surgical emergency measure. The current state of trade policy is one of aggressive pivoting. Following the court's decision, the administration moved within hours to preserve its agenda by invoking Section 122 of the Trade Act of 1974. This stopgap measure allows the president to impose across-the-board tariffs of up to 15% for a maximum of 150 days, without prior congressional approval. While this maintains some leverage, it creates a temporary and volatile environment. Meanwhile, existing duties under Section 232, targeting national security, and Section 301, targeting unfair trade practices, remain active. The administration is now accelerating new investigations under these specific authorities to create a more permanent legal foundation for the duties the Supreme Court just dismantled. The clash centers on the definition of executive necessity versus statutory limits. On one side, the administration argues that the president requires flexible, rapid response trade tools to protect domestic industries from foreign market manipulation and to maintain geopolitical leverage. They view the International Emergency Economic Powers Act as an essential instrument for modern economic statecraft, where trade and national security are inseparable. On the opposing side, the commercial community and constitutional purists argue that the executive branch has overstepped its bounds, transforming emergency powers into a permanent tax on consumers. They point to rising costs on holiday goods and raw materials as evidence of the negative fallout, asserting that trade policy must return to a predictable, legislatively guided framework to prevent market instability. Looking forward, the trade landscape faces three immediate developments. First, a wave of litigation is expected in lower courts as manufacturers and importers seek refunds for billions in tariffs paid under the now invalidated International Emergency Economic Powers Act authority. Second, because Section 122 expires in 5 months, expect a high-stakes legislative battle in Congress to either extend those powers or reclaim them entirely. Finally, the administration's shift towards Section 301 investigations suggests a new era of highly specific, product-by-product trade barriers that will require businesses to maintain meticulous documentation to navigate. The Supreme ruling hasn't ended the trade conflict, it has simply moved the battlefield, from the Oval Office to the courtroom and the committee room.